Chapter 35 Will Planning, Drafting, and Execution 1. Introduction. The lawyer who is called upon to draft a will for a client carries a heavy onus. As well as being accountable to the client, the lawyer may also be liable to the intended beneficiary or beneficiaries for any act or omission in carrying out the instructions of the client that frustrates the client's testamentary intentions. The lawyer's responsibilities encompass taking necessary steps to ensure each of the following. The client has testamentary capacity. The client's expressed wishes are not the result of undue influence or duress exerted by others. The client provides a full and accurate inventory of the client's property, together with any information or documentation that may have a bearing on the client's authority or ability to dispose of any of the property. The client is apprised of relevant income tax issues and other issues or limitations that may affect the client's proposed scheme of distribution. The client understands and approves of the contents of the will. The appropriate degree of diligence is applied to see that the will is signed on a timely basis. There is compliance with the statutory formalities for signing the will. The lawyer should ensure that the will is drafted in language sufficiently clear and unambiguous so as to minimize the likelihood of an application for the advice and direction of the court as to the meaning of the particular words used. This would include taking appropriate care in descriptions of specific property and of the intended beneficiaries, whether described by name or by class, as well as in the description of any conditions governing entitlement of a beneficiary to a bequest or devise. The lawyer should also ensure, as much as possible, that there are no practical barriers in the way of the estate trustee's administration of the estate. For example, the will should give appropriately extensive powers and authority to the estate trustee. This will minimize the likelihood of an application to vary the terms of a trust set out in the will so as to expand the estate trustee's authority to permit particular actions. Finally, it is a prudent post-signing practice for the lawyer to alert the client to future events that may require a review of the will to see if it is still appropriate. Such events would include, for example, marriage, divorce, births, deaths, adoptions, changes of domicile or residence, and substantial changes in net worth. 2. Client communications. Generally, it is only through communication with the client that the lawyer can fulfill a number of the duties referred to above. For example, that communication, assuming it is properly conducted, will allow the lawyer to ascertain whether the client has testamentary capacity, whether any undue influence or duress is at play, the client's personal and financial circumstances relevant to the exercise of drawing a will, the client's testamentary intentions, and the client's understanding and approval of the contents of the will as drafted. The lawyer should ensure that the file notes contain sufficient information to support the affirmative conclusions as to I. Testamentary capacity, and 2. Absence of undue influence or duress. Such notes may assist the estate trustee in a subsequent will challenge where the presumption as to the testator's testamentary capacity and knowledge and approval of the contents of the will has been spent as a result of the presence of suspicious circumstances. Vout v. Hay 2.1 Testamentary capacity. A lawyer should consider whether the testator is legally capable of disposing of assets by will. First and foremost, does the testator have the requisite degree of mental competence to give instructions for a will? For the will to be valid, a person must be capable of understanding the nature and extent of the assets and of comprehending and appreciating the persons who should receive the assets, sometimes described as the natural objects of his/her bounty. The testator may be eccentric or may lack capacity one moment and be lucid the next. Although the test for determining testamentary capacity is a legal one, the lawyer should be sensitive to situations that would warrant calling on outside expertise, whether in the realm of medicine or psychology, to test the mental faculties of the would-be testator. Since it is the duty of the lawyer to ascertain the testator's mental capacity, it is clear that the lawyer must have an opportunity to observe, interview, and assess the testator in person. Taking instructions over the telephone or, worse still, through an intermediary, is not sufficient, unless the lawyer ultimately meets with the testator in person prior to the wills being signed. Where the client is either ailing or elderly, the lawyer must be especially alert to capacity issues. The lawyer must make a professional judgment as to whether the lawyer is prepared to take initial instructions from another family member and then confirm capacity in a meeting with the testator to sign the will. There are risks associated with this approach. First, suppose it is clear at the meeting that the testator lacks testamentary capacity and will not likely recover it. In that case, the lawyer may be in an awkward position when it comes to getting paid for the time spent. Second, and more important, Suppose the lawyer is merely uncertain as to whether the testator has testamentary capacity and wants to have the comfort of an outside professional opinion. This will entail a further delay, during which time the testator may either die or fall clearly below the level of testamentary capacity. 2.2 Undue influence or duress. The instructions given must reflect the wishes of the testator. The validity of a will may be compromised, either in whole or in part, where the instructions given to the lawyer are the result of pressure brought to bear on the testator, pressure of such a degree that the testator has reached the point of thinking, "It is not my wish, but I must do it." This is especially true in the case of an ailing or elderly testator who may be heavily dependent upon another person for care or assistance. A person who may be in a position to exploit the testator's consequential vulnerability to pressure. Undue influence or duress may be subtle in nature. This is one reason that the lawyer should be wary about having anyone other than the testator present when instructions are being given or when the will is being signed. 2.3 Other communication considerations. A testator's personal circumstances can compromise the lawyer's ability to ascertain the testator's wishes and to assess testamentary capacity. The lawyer must be vigilant to ensure that those circumstances do not impair the lawyer's ability to conduct effective communications with the testator. In this regard, the lawyer should address with appropriate caution any invitation by another family member to act as that interpreter. Accepting such an offer may be tantamount to taking instructions second-hand, with all the dangers that entails. As an example, consider the situation in which the lawyer is not conversant in the testator's first language. In that case, serious consideration ought to be given to having an independent interpreter present for all meetings with the testator. Language is not the only impediment to effective communication. Illiteracy is common among adults in our modern society. The lawyer should be on guard for cues that indicate a testator's diminished literacy. Limited literacy skills can be problematic in at least two respects. They may interfere with the testator's ability to communicate to the lawyer either the nature or the value of the testator's property. This is simply one more justification for the lawyer to request documentation in support of asset information provided orally by the testator. They may compromise the testator's ability to understand the draft will when it is given to the testator for review and comment. Bear in mind that those afflicted by illiteracy are often at pains to hide that disability from others. The lawyer should not assume that a testator with limited literacy skills will disclose this problem to the lawyer. This is one justification, among others, for the lawyer to consider establishing a routine of reading or at least paraphrasing the key provisions of the will for the testator immediately prior to having the testator sign it. Not infrequently, it is the client personally who requests that a family member or other person attend the meeting where information is conveyed or instructions are given. There are problems with the lawyer's acquiescing to such a request. The lawyer will have no way of knowing whether undue influence or duress, which, as noted earlier, may be subtle in nature, may have been at play in motivating the client's request. Even if there was no undue influence or duress motivating the client's testamentary instructions, the presence of a third party at any meeting between the lawyer and the client may encourage or even facilitate a subsequent challenge to the validity of the will by someone who is unhappy with the scheme of testamentary distribution. The client may not appreciate that the lawyer's primary obligation to maintain confidentiality and preserve the privacy of the client's affairs will necessarily be compromised. The information or instructions conveyed by the client to the lawyer may come as a great surprise, indeed, a shock, to the other family member present. In the extreme, it could give rise to litigation, either as a consequence of disclosure of the client's previous actions or in attempts to interfere with the client's intention to make a new will should litigation ensue. The benefit of any privilege attaching to communications between the client and the lawyer may be lost. One final suggestion on effective communication with the testator. A lawyer should endeavor, wherever possible, to use plain language in all of the lawyer's writings. This should apply not only to the preparation of wills and other estate planning documents, but also to any correspondence sent to the testator. Even where language and literacy are not issues of concern, legalese may be a hindrance to effective communications. 3. Information gathering. Collecting complete and accurate information from the client, while essential to the proper discharge of the lawyer's role, is a stage in the process that is not always appreciated by the client, and sometimes not by the lawyer either. For example, if the whole of the client's estate is to be disposed of in exactly the same manner, to a spouse or marital partner, for example, the client is likely to question the importance of providing the lawyer with a detailed description of the assets, including their nature, location, value, details of ownership, and any limitations on the ability to dispose of them on death. For the lawyer to be able to overcome the client's reluctance to provide that level of detail, the lawyer must be able to provide a persuasive rationale for doing so. For example, the lawyer must be ready to explain how valuation may be relevant for purposes of assessing exposure of the estate to income tax and estate administration tax, how the nature and location of assets may raise questions as to whether the laws of some other jurisdiction may constrain the ability to dispose of those assets by will, that certain kinds of joint ownership will take the asset out of the estate of the client, and how the estate trustee may be legally bound by contract, e.g., a shareholders' agreement, a co-tenancy agreement, or a separation agreement, to deal with a particular asset on death in a manner contrary to what the client intends. Collecting information about the client's personal circumstances can be equally critical. Here are just a few examples. While unlikely to be an issue, has the client attained the age of majority, or is there an exception? For example, the client is married, in the armed forces, or a mariner at sea, that allows the client to make a valid will. A client living in a common law relationship or engaged to be married should be warned that a marriage subsequent to the signing of the will would revoke the will, unless the will contains a declaration that it is being made in contemplation of that marriage. Succession Law Reform Act (SLRA). A will declared to have been made in contemplation of marriage remains valid even if the marriage does not take place. Of course, if the marriage is called off, it may have a substantial impact on the testamentary intentions of the testator. If the client has an adult child who is living in a common law relationship, the lawyer should question the client on whether any children born of that relationship are to be included in the scheme of distribution. If anyone meets the definition of a dependent of the client, within the meaning of that term in the SLRA, the lawyer should explain a potential claim under Part 5 of that statute. If any one of the client's children has a disability, an exploration of the child's current financial needs and future prospects must be canvassed. If any of the client's children is married, a discussion of the implications of Ontario's Family Law Act (FLA) is in order. If the client has stored genetic material that may be used at a future time to conceive a child, the lawyer should ask whether the client intends to be a parent to such a child. By virtue of the enactment of the All Families Are Equal Act, Parentage and Related Registrations Statute Law Amendment, 2016, for all wills made on or after January 1, 2017, a reference in the will to a child of the testator, or of any other individual, for that matter, will be construed, in the absence of a contrary intention expressed in the will, to include posthumously conceived and born children. However, there are steps that must be taken by the spouse of the testator or other individual who has control of the genetic material in order to include such children. See Chapter 42 Administration of Estates. Of these study materials for more information. The lawyer who fails to obtain answers to critical questions regarding the client's personal and financial circumstances risks exposure to liability at the instance of a disappointed beneficiary. What is perhaps a more complex issue is whether the lawyer is entitled to rely on the information provided without asking for a copy of the documentation that would confirm the accuracy of a given answer. It is quite common, for example, that a client who has signed a separation agreement does not always know or accurately recall what support or property obligations will be imposed in the event of the client's death. At a minimum, the lawyer should ask for a copy of the separation agreement. If the client is unable or unwilling to provide that information, the lawyer should document that fact and make it clear that the client must assume the risk that the client's understanding or recollection of those obligations may be faulty. Similarly, it is good practice to ask a client to provide a copy of title documents for real property, particularly if that real property is held jointly with one or more other persons. Whether property is held in a joint tenancy or a tenancy in common makes all the difference in the world as to the freedom the client has to dispose of the client's fractional undivided interest in that property. With regard to joint bank accounts and joint investment accounts, ascertaining the client's intention in creating the joint account is essential. There are three possible intentions with regard to the rights of the other joint account holder. 1. The person is an equal owner of the funds or investments. 2. The person is a joint owner merely in order to be able to assist the client in managing the client's financial affairs. And 3. As a result of the Supreme Court of Canada decision in Pecor v. Pecor, the person is entitled only to receive whatever is in the account on the client's death. While it is important for the lawyer to record the client's intentions, They may not carry sufficient weight in a subsequent judicial proceeding if they were being expressed for the first time and it was long after the creation of the joint account. 4. Statutory constraints on testamentary freedom. 2. Ontario statutes may circumscribe the client's testamentary freedom. 1. Part 5 of the SLRA, Dependent Support, and 2. Part 1 of the FLA, Property Rights of Married Spouses. The lawyer must be alert to these limitations and advise the client accordingly in situations where a client's testamentary intentions may be foiled by a dependent support claim or by a matrimonial property claim. 4.1 Dependent Support Claims. Part 5 of the SLRA is intended to ensure that certain persons who were financially dependent upon the deceased during the deceased's lifetime are not put into dire straits by virtue of inadequate provision having been made by the deceased for those persons. In order to make a claim under Part 5 of the statute, 3 criteria must be met. The claimant must stand in the right relationship to the deceased, namely, be a married or common law spouse, parent, grandparent, child, grandchild, or sibling of the deceased, with the parent-child relationship encompassing situations where the former has demonstrated a settled intention to treat the latter as a child of his or her family immediately prior to death. The deceased must have been actually providing support to the claimant or have been under a legal obligation to do so. The deceased did not make adequate provision for the claimant. Prior to the Ontario Court of Appeal decision in Cummings v. Cummings, adequate provision had been considered to be a reflection of the claimant's budgetary needs. Where the deceased's child or married or common law spouse is the claimant, those budgetary needs would take into account family lifestyle. As a result of the Cummings decision, there is at least one additional dimension to be considered in dependent support claims, namely, moral considerations are now firmly established as being equally as important as financial ones in the exercise of the court's discretion to fashion the appropriate remedy. The Cummings decision went still further with the remark that certainly appears to have been obiter. The court asserted that, insofar as a married or common law spouse is concerned, an equitable sharing of the family wealth is a legitimate objective of Part 5 of the statute. How this comment will affect the lower courts in the future remains to be seen. Since this pronouncement, at least one judge has categorically rejected the suggestion that the decision allows a court to take into account the respective wealth of the parties and reapportion the wealth in a fair manner. See Simpson v. Liardi. Nonetheless, the uncertainty that Cummings has brought must be made clear to the client. The client should also be apprised that the assets available to satisfy a dependent support claim include a number of categories of property that for all other purposes are not available to satisfy claims against the estate. These categories are set out in S72 of the SLRA. 4.2 Matrimonial property claims. The passage of the FLA in 1986 ushered in a matrimonial property regime in Ontario that was dramatically different from its predecessor in 3 respects. The distinction between shareable family assets and generally non-shareable non-family assets was abolished. The matrimonial property rule of an in specie division of family assets was replaced by a division of value. The rules became applicable even where a marital relationship ended with the death of one of the spouses. Will planning became much more complex as a result of this last mentioned change. Absent a marriage contract waiving it, a surviving spouse now has the right to choose between accepting the entitlement under the will and claiming an equalization payment representing a sharing of the marriage spoils, unless the will provides that the surviving spouse's entitlement, if any, under the will is in addition to the equalization entitlement. The surviving spouse will be put to an election, having to choose either the former or the latter. If the latter is chosen, the will entitlement is forfeited, and the will is administered as if the surviving spouse had predeceased the testator. Theoretically, a will leaving anything less than 100% of the estate to the surviving spouse raises the specter of the spouse's choosing to elect in favor of an equalization claim. It might be thought that the way to avoid that risk is to provide a will entitlement to one spouse that is guaranteed to be not less than the equalization claim. There are at least 3 reasons why this strategy may not be effective. In most cases, each spouse's net family property, broadly stated, a measure of the increase in a spouse's net worth during the marital relationship, is a moving target, that is, the value of each spouse's net worth on the valuation date, and therefore, each spouse's net family property will not be known at the time the will is drawn, although the general rule is that the equalization claim, if any, is 1/2 the amount by which the deceased spouse's net family property exceeds the surviving spouse's net family property. S5, 6. of the FLA sets out a number of factors that entitle the court hearing an application to order an equalization payment that is more or less if an equal division of net family properties would be unconscionable. The equalization claim is calculated on the basis of asset values on the valuation date even if the estate value declines substantially after the deceased's death. For example, suppose the surviving spouse's net family property is nil and the deceased spouse's net family property is $400,000. The surviving spouse would be entitled to an equalization payment of $200,000. Suppose the deceased spouse had chosen to err on the side of caution and leave by will to the surviving spouse 60% of the estate. Finally, suppose the value of the estate had declined to, say, $150,000 by the time the equalization payment was ordered to be made. In this situation, the surviving spouse would be better off electing in favor of equalization, giving the surviving spouse the whole of the estate in satisfaction of the $200,000 equalization payment, as compared to taking 60% of $150,000 or $90,000. By accepting the will entitlement. Prior to the enactment of the FLA, one would frequently be instructed by the testator to prepare a will granting the spouse a life interest in the estate, with the remainder interest passing to the testator's children, who might or might not have been born of the union between the testator and the spouse. The rationale was that this would protect the estate for the testator's children after the spouse's death, thereby guarding against loss because the surviving spouse might enter into a new marital relationship and leave the entire estate to the new marital partner, or might be incapable of managing the inheritance wisely. Now, the life interest is no longer a guaranteed strategy because the surviving spouse can forego it in favor of an equalization claim. What advice can be given to the client whose testamentary plans are vulnerable to an equalization claim? Without question, the best legal advice is that the client should have a marriage contract with the spouse under which, in exchange for appropriate consideration, the latter will give up any right to elect in favor of an equalization claim. However, since an enforceable marriage contract calls for independent legal advice and full financial disclosure to be given to both parties, the practical prospect of obtaining a marriage contract may be small in a particular client's situation. The other alternative is the self-help remedy, that is, unilateral steps by the client to minimize the exposure to an equalization claim on death. This would entail maximizing opportunities for excluding the value of assets from one's net family property, minimizing one's net worth on the valuation date, or a combination of the two. Taking optimum advantage of the opportunities to exclude asset values from net family property may involve nothing more than keeping careful records that will support a later position that a particular property belongs to one of the categories of excluded property as for minimizing net worth on the valuation date. The lawyer should caution the client that a disposition of property for the sole purpose of reducing a spouse's equalization claim could, under the appropriate circumstances, be set aside as a fraudulent conveyance. Stone v. Stone. The lawyer may be in an awkward position when asked to take instructions for wills for both spouses where one spouse intends, absent a marriage contract, to leave less than the entire estate to the other spouse. The conflict of interest for the lawyer will become apparent only after that spouse discloses his or her testamentary intentions. At that point, the lawyer must decide whether the lawyer can act for only one of the spouses, or perhaps for neither of them. The lawyer should become familiar with the commentary found in R 3.4-5 of the Rules of Professional Conduct, which deals with the joint retainer of spouses or partners, as the latter term is defined in the Substitute Decisions Act, 1992 SDA. In the preparation of wills, when meeting with a joint retainer couple for the first time, or perhaps even before that first meeting, the lawyer should ask the clients to sign a form of acknowledgement and consent regarding the constraints imposed on the lawyer's conduct as set out in that commentary. There is another reason why will planning requires the FLA to be taken into careful consideration. The client may have concerns that the inheritance passing to the client's children will be exposed to an equalization claim by a present or future son-in-law or daughter-in-law. Certain strategies can be suggested to the client in this regard. As a general rule, gifts and inheritances received by a spouse during marriage are excluded from the recipient spouse's net family property. Income derived from gifts and inheritances received during marriage is also excluded, provided the donor or testator expressly so stated. If the gift or inheritance is received prior to marriage, its value at the marriage date will represent a deduction in calculating the child's net family property at a later time. Furthermore, there will be an opportunity for the child to enter into a marriage contract prior to the marriage where a parent intends to forgive a debt owed by a child. It will be of benefit to the child only if the debt is forgiven before the child's marriage, assuming it is not a mortgage debt associated with the property that becomes the child's matrimonial home upon marriage. In that case, it will increase the child's net worth on the date of marriage, thereby giving the child a larger opening credit in later calculating net family property. By contrast, forgiveness of a debt owing by a married child serves only to increase the child's net worth on the valuation date, thereby increasing the child's net family property calculation. The client who wishes to provide greater protection for a child can establish a discretionary testamentary trust for a child, instead of making an outright bequest. There are several caveats to the foregoing. A matrimonial home is the exception to the rule regarding gifts and inheritances received during the child's marriage. This can be problematic where the parent intends to leave a married child all or a fractional interest in a family cottage. Regular use of the cottage by the child and the child's spouse would make it a matrimonial home if the parent forgives a mortgage on a child's matrimonial home or if the child spends inherited cash to pay down the mortgage. The child's net family property will be increased even though the value of a gift or inheritance received during marriage is excluded from the child's net family property. It may still be vulnerable to an equalization claim in that its value can be used to satisfy that claim, where the child's other assets are not sufficient for that purpose. The onus of proving entitlement to an exclusion of a gift or inheritance received during marriage lies with the spouse claiming it. If the child has been careless in segregating an inheritance or in keeping records to prove the source of a particular inheritance or how it may be traced into other property, the claim for an exclusion may fail. 5. Mutual wills where a marital couple, married or common law, present themselves to the solicitor with a request to have wills made for each of them. There is usually an expectation that they have reached a common understanding as to how their respective estates will be disposed of, irrespective of which of them survives the other. This may be so even where either of the parties has children from a prior relationship. However, after both parties have made such wills, once one of the parties dies, the survivor may decide to dispose of the survivor's property in a different manner and make a new will to reflect that decision. The mutual wills doctrine provides that where two parties have made a contract that, having made wills together, neither of them will change his or her will after the death of the other, the survivor takes any property acquired under the will of the deceased on trust, to deal with it in the same manner as is set out in the will that the survivor made at the same time as the deceased made his or her will. Whether that precludes the survivor from disposing of such property during the survivor's lifetime is a topic that is beyond the scope of this chapter. The case law suggests that, in the absence of a written agreement that the wills are intended to be mutual ones rather than simply mirror wills, the courts are unlikely to establish an oral contract to make mutual wills. That said, there are cases where the court has found the existence of such a contract on the basis of all the surrounding circumstances. See, for example, Ramage v. Estate of Roussel. As a result, the solicitor should take pains to raise this issue with the couple at the initial interview and ask whether either party would object if the other, upon surviving, chose to make a new will with a different testamentary disposition. If an objection is raised, this may give rise to a concern as to whether the solicitor can continue to act for both parties. However, it is at this juncture that the solicitor should raise the possibility of having the couple consider a domestic contract, within the meaning of that term in the FLA, whereby each party agrees, upon survival, not to change his or her will. All of the formalities for domestic contracts would have to be met and, of course, the solicitor, if competent to draft such a domestic contract, could not act for both parties in that regard. 6. Estate administration tax, formerly probate fees. In order to obtain an initial certificate of appointment of estate trustee, with or without a will, an estate trustee must pay an estate administration tax based on the value of the estate. After December 31, 2019, the tax is calculated on the following basis. The first $50,000 of estate value is exempt, while the rate is $15 per $1,000 or part thereof. For the estate value in excess of $50,000, the value of property falling into any of the following categories is excluded from the calculation of estate administration tax. Real property situated outside Ontario, real property situated in Ontario held jointly with another person, S, and passing by survivorship to such other person, S. Money or property owned by the deceased jointly with one or more other persons and passing by survivorship to such other person, S. The proceeds of life insurance payable on the death of the deceased to a designated beneficiary, and any benefits payable under a plan, within the meaning of that term under Part 3 of the SLRA, to a designated beneficiary. The value of any other property governed by the will is included in the calculation of estate administration tax. See, however, the commentary regarding life insurance payable to the estate in the Estate Administration Tax section of Chapter 42, Administration of Estates of these study materials. Generally speaking, debts and liabilities of the deceased do not reduce the value of the estate for the purpose of calculating estate administration tax. Under the Estate Administration Tax Act, 1998, the one exception to that rule is the value of an encumbrance registered against real property whose value is included in the property of the deceased person. 6.1 Reducing estate administration tax. Part of the lawyer's planning discussion with the client should include a consideration of what steps, if any, should be taken to reduce exposure to estate administration tax. Such steps might include the following: disposing of property during one's lifetime, either directly to the beneficiary ultimately intended to receive it on the client's death or to a trust such as an alter ego trust or joint partner trust, transferring property into joint ownership with one or more other persons, and ensuring that life insurance, RRSPs, RRIFs, TFSAs, and other plan benefits are made payable to a designated beneficiary, rather than to the client's estate. 6.1. Multiple wills. Under current Ontario law, the use of multiple wills is another technique for reducing exposure to estate administration tax. The essence of the scheme involves characterization of each asset owned by the client as either a bad one or a good one. Bad assets are those that require, either legally or practically, a probated will to transfer ownership from the name of the deceased. Each category of assets is governed by a separate will, with the intention that only the will governing the bad assets will be submitted for probate. The decision in Granovsky Estate v. Ontario confirmed that estate administration tax is payable only on the value of the assets governed by the will submitted for probate. The use of multiple wills is particularly effective where the client owns shares of a private corporation, since it is generally considered that shares of a private corporation held by a deceased shareholder can be legally transferred in accordance with an unprobated will. Strictly speaking, it is up to the director of the private corporation to decide what evidence will be acceptable to prove the authority of the estate trustee to direct what is to happen to the shares formerly owned by the deceased shareholder. Accordingly, the client should be cautioned about including in a separate will the shares of a corporation that is controlled by other persons. If the director of that corporation were to decide that probate of the will governing those shares was required, the scheme to reduce estate administration tax will come to naught. A private corporation controlled by the client can also be used as a bare trustee or nominee to hold the client's other valuable assets and, by appropriate drafting, have those assets governed by the same will that is to be withheld from probate. However, it is important that the corporation sign a trust declaration to confirm that it is not the beneficial owner of any of those assets that it holds as a nominee. First, this will prevent the Canada Revenue Agency from asserting that the client disposed of property that could give rise to immediate tax consequences. Second, it will protect those assets from the corporation's own creditors. The plan to use multiple wills to minimize estate administration tax can be undermined if, as a consequence of the testator's death, there is no longer a quorum of directors, or indeed, any director, who can continue to manage the day-to-day affairs for any of the corporations whose shares are to be governed by the will intended to be held back from probate, if it should become necessary for the estate trustee, as controlling shareholder, to vote in a new director. The corporation's banker may challenge the authority of the estate trustee to exercise those voting rights under the unprobated will. For that reason, a client who intends to have a separate will govern shares of a private corporation should be advised to have a lawyer review the corporate records of that corporation to ensure that this is not a problem and to take any necessary remedial action. For some time, it has been in vogue among lawyers who draft multiple wills to include a so-called basket clause of excluded assets, that is, a category of assets intended to be excluded from the scope of the will governing the bad assets. A typical form of wording of such a basket clause of excluded assets might be the following: any other assets for which my estate trustee determines a grant of authority by a court of competent jurisdiction is not required for a transfer or realization thereof. A recent decision in Dunphy J. Milne Estate Re. has raised concerns as to whether such a basket clause in a will might compromise the essential validity of that will. In that case, an order was sought, as required by R 74.06, 1, c. 1, of the Rules of Civil Procedure for the issuance of a certificate of appointment of a state trustee with a will limited to the assets referred to in the will. The judge refused to do so because he was not satisfied that there were any assets that could be objectively ascertained to be governed by the will in question. Not long after the decision in Milne Estate, a decision by Penny J. in Panda Estate Re. likewise dealt with a similar request where the will in question contained a similar basket clause. Penny J. expressly rejected the analysis of Dunphy J. and issued the order sought. More importantly, the decision in Milne Estate was overturned by the Divisional Court, which rejected Dunphy J.'s analysis for the same reason Penny J. did. 6. 1. 2. Transfer of property into joint ownership. The potential adverse consequences of transfers of property, typically by a parent to a child, into joint ownership with right of survivorship are many. They include the following. The testator parent will lose exclusive control over the property. For example, where a parent transfers real property into joint ownership with a child, any subsequent decision to sell or encumber the property will require the consent of the child. The child will also have to consent to a transfer of the child's 1/2 interest back to the parent. For example, because future changes to the provincial estate administration tax regime substantially reduce or eliminate the need to avoid those taxes where the child has financial problems. The child's creditors will have access to the fractional interest in the property, possibly leading to a partition and sale where property qualifies as the child's matrimonial home under the FLA. The joint tenancy will be deemed to have been severed if the child predeceases the parent. The parent may have made a taxable disposition for income tax purposes. In some cases, this may result in the triggering of an immediate and significant income tax bill, hardly a beneficial outcome in trying to avoid a substantially lower future liability for estate administration taxes if, under the Income Tax Act, the property transferred is the parent's principal residence and if it is not the child's principal residence, the transfer will result in a loss of a portion of the principal residence exemption for future taxation years. Careful attention should be paid to cases where a client advises the lawyer of a previous transfer of property formerly held by the client alone to the client and the client's adult child as joint owners with right of survivorship. Of particular concern will be transfers to joint ownership with an adult child where the parent has another child or children. Did the parent intend to make a gift exclusively to the adult child with whom joint ownership is shared? Or was the transfer made with some other objective in mind? The Supreme Court of Canada held in Pecor v. Pecor that in a legal dispute over ownership of property that was jointly held between a now deceased parent and an adult child, absent satisfactory evidence to demonstrate the parent's intention to make a gift to that adult child, the presumption of a resulting trust will be applied, in which case the property will belong to the parent's estate, giving rise to additional estate administration tax. To minimize the likelihood of later disputes over ownership, the solicitor should encourage the client to document whatever that intention might be. Where the client is clear that the jointly held property is to be distributed in accordance with the client's will, strong consideration should be given to having such property governed by a separate will not intended to be submitted to probate. 7. Income tax. One cannot engage in a meaningful discussion with the client about the client's testamentary intentions without a good understanding of the special income tax rules that arise on and after the death of an individual. Without intending to be exhaustive, the key considerations are as follows. An individual is deemed, immediately before death, to have disposed of capital property and land inventory at its then fair market value. The capital gain is included in the tax return for the deceased's year of death where capital property or land inventory is transferred as a consequence of death, to a surviving spouse or common law partner, or to a testamentary trust for the exclusive lifetime benefit of the surviving spouse or common law partner. The property will transfer at its tax cost to the deceased, unless the personal representative elects to have the property transfer made according to the previous rule. Capital gains from a deemed disposition of qualifying small business corporation shares, qualified farm property, or qualified fishing property may be sheltered under an individual's lifetime capital gains deduction. The maximum is indexed annually. For 2020 it is $883. 384 charitable gifts made by will give rise to a tax credit that, if large enough, can reduce to 0. I. The taxable income in the year of death, and 2. the taxable income in the year preceding the year of death. New in 2016. In the first 60 months following death, the tax credit may also be applied against taxable income of the estate for the taxation year in which the donation is made. And 2. In the first 36 months after death, the tax credit may be applied against taxable income for a taxation year of the estate preceding the taxation year of the estate in which the donation is made. Direct charitable beneficiary designations for RRSPs, RRIFs, TFSAs, and life insurance give rise to similar tax benefits. The general rule is that the value of RRSPs and RRIFs as at the date of death of the deceased annuitant is included as income of the annuitant for the year of death, to the extent that the RRSP money or property qualifies as a refund of premiums or, in the case of a RRIF, as a designated benefit. The value of the money or property can be taxed in the hands of the recipient or, depending on the facts, can be further sheltered from tax by transfer or rollover to particular structures where a trust is to be established that may run for an extended period of time. The income tax rules impose a fiction of a deemed disposition, i.e., sale, of capital property at certain times, every 21 years or, in the case of a testamentary spousal trust, on the death of the spouse or common law partner. It is important that the client understand the tax liability arising on death in connection with a particular asset, e.g., capital property, land inventory, RRSP, or RRIF, does not, except in the case of one of the rollovers described above, follow the asset into the hands of the recipient. Rather, it is a liability of the estate. This may result in a distribution of estate value among two or more beneficiaries that is dramatically different from what the client intends. If this is a problem, it can be addressed by appropriate language in the will that requires the recipient to pay personally the tax relating to that asset. In the case of an RRIF or RRSP passing directly to the recipient as a designated beneficiary, the leverage on the recipient to pay the tax would likely be in the form of a reduction in that recipient's entitlement under the will should the tax not be paid within a specified time frame. 8. Foreign laws. If the client is a citizen or resident of, or owns property situated in, a foreign jurisdiction, the lawyer should be cognizant of taxes and death or succession duties in that other jurisdiction, and possible legal constraints on testamentary dispositions of property in that other jurisdiction. This may entail retaining local counsel in that other jurisdiction. 9. Client instructions. When taking the client's instructions, the lawyer must ensure that the lawyer clearly comprehends and faithfully records those intentions. The lawyer must be ready to offer appropriate guidance, whether or not requested to do so by the client, so that the client gets not only what the client wants, but what the client needs as well. 9.1 Appointment of estate trustees. The estate trustee has a very clearly defined role in administration of the estate, attending to the funeral and burial arrangements, proving the will, if necessary, collecting and protecting estate assets, paying creditors and satisfying liabilities including taxes owing, distributing specific bequests and conveying devises of real property, and finally, distributing the residue of the estate. In the case of a trust will, the estate trustee may also have to establish one or more trusts for specified beneficiaries and administer any such trust until the time specified for final distribution. In many instances, the appointment of estate trustees to administer the estate in accordance with the terms of the will is a straightforward proposition, where neither the structure of the testator's estate nor the nature of the intended distribution is complicated. There are unlikely to be any minefields. Suppose, for example, one marital partner intends to distribute to the other marital partner his or her entire estate, which consists principally of liquid assets. In that event, it would be appropriate to appoint the other marital partner as the sole estate trustee, unless the latter has significant limitations, health or language, for example, that would warrant a different appointment. Similarly, an outright distribution to one or more legally capable adult children will often warrant appointing the child, Ren, as estate trustee. It is not uncommon for a client to instruct the lawyer to draft the will with the appointment of two or more persons as joint estate trustees. On receiving such instructions, the lawyer should canvass with the client a number of issues, having regard to the fact that the estate trustees must act jointly, where there are more than two estate trustees, how decisions are to be made, I. Unanimously, 2. By majority, or 3. By majority with one specified estate trustee having to be part of that majority, that is, having a veto. The likelihood that the estate trustees will be able to work together without serious conflict. The problems that may arise if the estate trustees live far from one another. The client with several adult children will often wish to appoint all of them jointly, out of worry that leaving one out will create unhappiness for the one excluded. The best response to such a client is to point out that the appointment as estate trustee is a burden, not an honor, and to sell the idea of excluding one or more of the children from the role of the estate trustee on such a rationale. Other issues arise when there are unusual assets or foreign elements, or where the administration of the estate is expected to be a protracted affair. Appointment of a foreign estate trustee, that is, one who is neither resident in a Canadian province or territory nor resident anywhere in the British Commonwealth, will likely require a foreign estate trustee's bond. More important than the added cost of a bond is the question of whether a bonding company can be found to issue one. Practitioners have found that most bonding companies are very reluctant to issue a bond for an estate trustee outside North America, usually leading to the foreign estate trustees having to renounce the appointment to allow a local estate trustee to take on the appointment. One further issue may arise where a client with an investment portfolio intends to appoint a U.S. resident, typically a child of the client, as an estate trustee. Canadian brokerages are evidently heeding the warnings from the U.S. Securities and Exchange Commission against taking trading instructions respecting Canadian assets from a U.S. resident. Client appointment of an estate trustee who may have an inescapable conflict of interest is problematic. It is not uncommon, for example, that a testator will consider a business partner of many years to be a competent and trustworthy individual to act as estate trustee. If the business agreement between the testator and business partner entitles or requires the latter to buy out the former's interest in the business venture, the partner will be wearing two hats, that of a seller and that of a buyer, an untenable position if there is any element of negotiation required under the business agreement where assets are complex in nature. It may be desirable to appoint an estate trustee, or at least one of the estate trustees, with particular expertise in relation to those assets. A prolific author-artist may be well advised, for example, to appoint a literary art estate trustee with responsibility for disposing of the testator's collection. That having been said, there is no reason why the estate trustee cannot hire the necessary talent to assist in dealing with unusual assets where the potential exists for an estate to run for many years. Say, for example, because a trust is to be set up for a disabled child with a normal life expectancy, it would be prudent for the testator to appoint a trust company, either together with, or as a substitute for, an individual estate trustee, to deal with the contingency of the individual estate trustees dying or becoming incapacitated before the estate has run its course should the client's surviving spouse choose to make an equalization claim against the estate under the FLA. The surviving spouse will forfeit the right to act as estate trustee. Accordingly, where there is a risk of such an equalization claim, the client should either not name the surviving spouse as estate trustee or should name one or more other persons to act as estate trustee, together with or as alternative, to the surviving spouse. Merely as an aside, a will is not invalid only because it fails to make an express appointment of an estate trustee. Sometimes, despite the absence of an express estate trustee appointment clause, an individual, by virtue of having been directed to carry out certain tasks that would normally be the responsibility of the estate trustee, may be considered to be the estate trustee by tenor of the language used. 9.2 Custodians for minor children. Clients often find that the most difficult decision in planning for death is determining who shall have custody of any minor children. Indeed, parents are often in conflict on this issue. The couple's inability to reach a consensus on this issue is often the reason that neither has made a will. The Children's Law Reform Act permits the parent with custody of a minor child to appoint a custodian for the child in the parent's will. In the case of two parents having custody of a minor child, the testamentary appointment of a custodian will fall to the later of the two parents to die. If the parents were to die simultaneously, the only effective appointment will be one common to both wills. So, for example, if the mother appoints A and C as custodians and the father appoints B and C as custodians, the simultaneous deaths of the mother and father would result in C alone having legal custody of the minor child. Ren. The lawyer should point out the following matters to the client, wishing to include a testamentary custodial appointment for minor children. The appointment is legally effective for only 90 days after the testator's death. Thereafter, it will be necessary to apply to the court for a permanent custodial appointment. assuming one is felt to be necessary on an application for appointment of a permanent custodian, the following will occur. The court will do what is in the best interests of the minor child. Ren. Courts give considerable weight to the parent's testamentary choice of custodian. Courts are generally reluctant to disturb the status quo, i.e., the temporary custodial arrangement without good reason. Where the minor child is sufficiently mature, the court will solicit the child's views on a custodial appointment. 9.3 Guardians of property of minor child. Appointment of a guardian of a minor child's property can also be effected by a will. The rules for testamentary appointments of a guardian of a minor child's property are analogous to those for testamentary appointment of a custodian of a minor child's person. However, one cannot make a testamentary appointment of a guardian of a minor child's property unless one is a guardian of that child's property. In Ontario, a parent is not automatically the minor child's guardian of property. That requires a court order. As a result, the parent who does not have a court appointment as guardian of the minor child's property has no authority to appoint a guardian of property by Will. 9.4 Funeral and burial instructions. As a matter of law, the estate trustee has control of the body and therefore has the authority to determine the place and manner in which the funeral and, if applicable, the burial will take place. In this regard, the testator cannot bind the estate trustee by means of instructions in the will. In any event, the will may not be discovered in time to carry out any instructions it contains regarding funeral and burial arrangements. For these reasons, the lawyer ought to discourage the client from including funeral and burial instructions in the will. A better choice would be simply to ensure that every family member who may be called upon to look after funeral and burial arrangements is made aware of the client's wishes. The estate trustee is often not brought into the picture until after the funeral and burial arrangements are attended to by family members. The only practical benefit for including funeral and burial instructions in a will is that the estate trustee who follows those wishes will be able to point to the will to defend the estate trustee's actions. 9.5 Beneficiaries. The lawyer should canvass a number of issues with the client with regard to choice and identification of beneficiaries, as well as to the conditions, if any, on the gift. Proper description of each beneficiary, whether by name or by class. In the case of a named individual, ask for the relationship, if any, to the client and the city of residence to assist the estate trustee. In the case of a description by class in terms of legal relationship, ensure that the client understands that stepchildren do not normally fall within the meaning of children, and likewise for step-siblings. Confirm whether the client intends to include or exclude a person born outside marriage or the tracing of his or her entitlement through a person born outside marriage, the default being inclusion of such persons. Unless the will provides otherwise, ascertain when the class is to close, date of the testator's death, date of death of life tenant, etc., explaining to the client, where appropriate, the administration problems that could arise from requiring a class to be kept open out of fairness. For charitable bequests, if possible, confirm the name by contacting the charity directly or by looking up the name on the Canada Revenue Agency website, https://www.canada.ca, and Revenue Agency Services. Charities. Giving charities. Listings. HTML, where the client's bequest is motivated in part by tax considerations. In the case of a specifically named charity, ensure that the recipient is a registered charity for income tax purposes where the executors are given authority to choose the recipient. Having regard to the purposes intended by the bequest, ensure that the purposes are exclusively charitable for gifts other than cash or property that can be readily sold. Confirm that the charity is prepared to accept the gift. Clarify with the client the nature of a cash bequest. For example, outright bequest, perpetual gift, or gift for a specified purpose. Discuss what is to happen if the charity does not exist or changes its objects by the time of the client's death in the case of an outright bequest, or at some later time in the case of a perpetual gift. Where conditions on a bequest are imposed, consider or ensure the following: whether the condition is to be a condition precedent or a condition subsequent, that the condition will not be unenforceable on grounds of public policy, that the condition will not be void for uncertainty, and that the estate trustee will be readily able to ascertain on an objective basis whether the condition has been satisfied. 9.6 Dispositions of property. Where specific property is being disposed of, explore the following issues with the client. Description of the property should be sufficient for the estate trustee to identify it as the object of the bequest. Consider whether there are constraints on the client's legal ability to direct disposition. including the nature of client's ownership interest, joint tenancy, life interest, etc., and any agreements with third parties, for example, shareholder agreements, marriage contracts, or separation agreements. Consider the contingency of prior disposition of property by the client. Should the bequest govern any replacement property, the family home? For example, should the bequest deem, i.e., should it fail because the specific property is no longer owned by the testator at death, should a replacement bequest be made to the beneficiary, for example, a cash bequest? In addressing these issues, the lawyer should keep in mind the possible application of certain statutory anti-ademption rules. The SLRA gives a beneficiary rights in limited circumstances with respect to property substituted for the property gifted to the beneficiary in the will. Those circumstances are as follows: a conveyance or other act relating to property that gives rise to a right, chosen action, or equitable estate or interest, loss or damage to property giving rise to a right to insurance proceeds, expropriation of property, giving rise to a right to compensation, and a mortgage, charge, or other security interest in property sold by the testator. In those cases, absent a contrary intention in the will, the beneficiary who would have taken the property in question is entitled to the testator's interest that has been substituted for the testator's interest in that property. Consider the following example. The testator's will leaves Blackacre to her sister, Jane. Prior to her death, the testator enters into a purchase and sale agreement whereby she agrees to sell Blackacre to a third party for $300,000 in an all-cash transaction. The testator dies before the closing. Although at the time of her death, the testator is no longer in a position to convey Blackacre to Jane, Jane will still be entitled to the $300,000 payable on closing. As a further illustration of this anti-ademption rule, let us change the facts slightly. Suppose, instead, that the purchaser is to pay $100,000 on closing and give the testator a mortgage for the remaining portion of the purchase price. Suppose that the testator dies after closing. In that case, Jane will be entitled to an assignment of the mortgage receivable. The SDA also contains a special anti-ademption rule that can apply where specific property of a person who is incapable of managing property is the subject of a bequest or devise in that person's will, and that property is disposed of by the person's attorney under a continuing power of attorney or by a guardian of the person's property, unless the person's will evidences a contrary intention. The beneficiary who was to receive the specific property will receive from the residue of the estate a sum of money equal to the proceeds of disposition of that property, without interest. Where the property in question is deemed, for income tax purposes, to have been disposed of by the testator at its fair market value immediately before death, the testator should be asked for a clear direction as to who is to bear any increased income tax liability arising as a consequence, the recipient of the property or the residuary beneficiaries. Absent any provision to the contrary, that tax liability will be borne by the residuary estate. 9.7 The family home, family cottage. The disposition of the family home and family cottage is often a difficult issue. The lawyer should start by explaining to the client the duty of the estate trustee to turn assets that are not income producing into ones that are. Accordingly, unless the estate trustee is given express direction and authority to retain the family home or family cottage for the benefit of specific persons, the estate trustee will be obliged to sell the property or properties in due course and invest the proceeds. Retention of the family home or family cottage is more important where the client leaves minor children surviving. Some of the questions the lawyer should pose to the client in this regard are the following. Should the family home be made available to the custodian and the custodian's marital partner and children, if any? If the custodian's own residence would be too small to accommodate an expanded family after the last of the testator's children has attained the age of majority, at what point will the child, Ren, be entitled to request the custodian and family, if any, to vacate the home after the last of the testator's children has attained the age of majority? Under what circumstances may the child, Ren, request that the house be sold? Similar questions may be posed regarding the family cottage. It is not uncommon that one, and usually only one, of the client's several adult children is living at home with the parent, with little likelihood that the child will be willing or able to move out in the future. In that case, the client may wish to leave the family home to that child as part of the child's share of the estate. This may be problematic if the value of the family home constitutes more than that child's equal share of the estate, particularly if the child is not financially self-sufficient. In these circumstances, the lawyer should very carefully canvass with the client as to which is the more important consideration: equality and immediacy of distribution of the estate, or accommodation of the needs of the stay-at-home child, where the family home will be given to the stay-at-home child as part of the child's share of the estate. The lawyer should discuss two issues with the client, and draft appropriately. Is the provision to apply to any property purchased in substitution for the current family home? Secondly, is the provision to apply in the case where the parent, S, may no longer be living in the home, by virtue of having been placed in an institutional setting for health reasons, where the testator intends to leave the family home or cottage to 2 or more children? The lawyer should discuss the issue of how title to the property is to be taken, where the respective fractional interests of the children are not equal. The only possibility is a tenancy in common, where those interests are to be equal. The choice is between a tenancy in common and a joint tenancy if the will is silent. The children will take title as tenants in common. In that case, the lawyer should discuss with the testator the key difference between the choices, namely, the right of survivorship associated with the joint tenancy, where the testator opts for the joint tenancy. The lawyer should also point out that each child may sever unilaterally the joint tenancy, thereby rendering it a tenancy in common and leaving the child free to devise by will the child's undivided fractional interest in that property. In the case of a family cottage, this will lead quite readily into a discussion of the merits of a co-tenancy agreement between or among the children governing, among other things, the right of each child to dispose on death of the child's fractional interest. If the testator likes the idea of a co-tenancy agreement and wants to refer to it in the will, the lawyer should clarify whether the reference is to be expressed as a mere wish or the reference is to be imposed on the children as a condition precedent to the devised will drafting. Once the lawyer has collected all the relevant information about the client and has a clear understanding of the client's objectives and instructions, the drafting stage can begin. 10.1 Administrative provisions. There are a number of administrative powers that are desirable to include, since they will facilitate the proper administration of the estate, including the following: complete sales and conversions, pay debts, deal with the minor share of the estate, delegate investment discretion, deal with interests in companies and other business and partnership interests, deal with real estate, deal with notes and guarantees, distribute estate in specie, that is, divide assets between the beneficiaries without first converting them to cash, determine capital and income, lend and borrow, take estate trustees' compensation prior to a passing of accounts, and make income tax elections. One power that may be helpful, although it is dependent on the client's intentions and circumstances, is the power to purchase estate assets for the estate trustee's own benefit. Without an express authority to purchase estate assets, the estate trustee will have to obtain approval from all of the beneficiaries or from the court if any of the beneficiaries is a minor. A failure to do so could expose the estate trustee to a court order requiring the disgorgement of any and all future benefits accruing to the estate trustee as a result of the purchase, notwithstanding a purchase at fair market value and on fair market terms. 10.2 Memoranda incorporation by reference. For various reasons, the client may not wish the lawyer to have the will set out in express terms a long list of dispositions of personal effects. If the client is content that the estate trustees will give effect to the client's wishes, though they are not legally binding, the will may refer to a memorandum that the client prepares at some future time, and amends from time to time, and keeps among the client's personal papers. If the client expects the dispositions to be testamentary, that is, binding on the estate trustees, the lawyer should instruct the client to prepare the memorandum before the will is signed and advise the client that any changes made to the memorandum subsequent to the will signing have no legal effect. The will can then direct the estate trustees to dispose of the personal effects referred to in the memorandum, the description of which document should be detailed enough so as to identify it with clarity and in accordance with that memorandum. That such a memorandum can have legal effect flows from the doctrine of incorporation by reference. For this doctrine to be invoked, the memorandum must have come into existence prior to the signing of the will, and the court must have no doubt that the document is the one referred to in the will. There are no witnessing or other formalities for making a memorandum intended to have legal effect. However, it will obviously be desirable to have the client date the document, as evidence of its predating the signing of the will, and sign the document, as evidence that it was the client who prepared it or that the client acquiesced in its content. 10.3 Inadvertent distributions. A client who has gone to the trouble of engaging a lawyer to draw a will assumes that the will is going to direct the intended distribution of the whole of the client's estate in all circumstances. However, the lawyer who fails to take adequate care in interviewing the client, or drafting the will may inadvertently omit to address a scenario, resulting in an unintended disposition. 103. 1 Lapse. Lapse. People occasionally die in the wrong order. For that reason, the lawyer should take care that every testamentary disposition to an individual beneficiary addresses the contingency that the beneficiary is not alive at the relevant time to receive the entitlement. The relevant time may be the death of the testator or of another person. As a general rule, where a beneficiary predeceases the testator, the intended testamentary gift will lapse. Section 23 of the SLRA provides that, absent a contrary intention contained in the will, where a bequest or devise to a beneficiary fails because of the beneficiary's predeceasing the testator, the bequest or devise falls into the residue of the estate. Where the interest fails because of a predeceased residuary beneficiary, the interest will pass as on an intestacy. Class gifts are not subject to this lapse rule, since the testator is considered, in such circumstances, to have expressed the requisite contrary intention. If one or more members of the class should predecease the testator, the bequest passes to those members of the class still alive on the death of the testator. Section 31 of the SLRA is an anti-lapse provision that may take effect in the case of a devise or bequest to a child, grandchild, or sibling of the testator who predeceases the testator and leaves a married spouse or issue. In that event, and absent a contrary intention in the will, the bequest or devise does not fail but passes as if on an intestacy of the deceased beneficiary, but without a preferential share for the surviving spouse, if any. It appears to be an open question as to whether, in the case of a bequest of movable property, it is necessarily the intestate succession laws of Ontario that would apply in a case where the deceased beneficiary was domiciled outside of the province at the time of death. Suppose, for example, the testator's will makes a $90,000 gift to the testator's son who predeceases the testator, leaving a surviving spouse but no surviving issue. Unless the will provides a contrary direction, the son's widow will receive the $90,000 bequest. If a wife and 3 children had survived the predeceasing son, the wife would have received $30,000, and the children would have shared the remaining $60,000 equally among themselves. Typically, the contrary intention that would avoid the application of the anti-lapse rule is a stipulation that the intended beneficiary be alive on the testator's death. Had the bequest in this example stated to my son, if he survives me, the sum of $90,000, the legacy would have lapsed entirely. The lawyer should not presume what the client would have intended in the event of a particular beneficiary's predeceasing the testator. Rather, the issue should be canvassed expressly with the client to learn of the client's intention. Sometimes, the client will wish there to be a gift over to the children of a predeceased beneficiary. Depending on the current state of the relationship with the daughter-in-law or son-in-law, the client may intend, or not, that the bequest to a predeceasing son or daughter pass to the widow. The lawyer should keep in mind that short of divorce, marital discord between a predeceasing child and his or her spouse will not preclude the operation of the anti-lapse rule, where the client wishes to provide, in the event of the married child predeceasing the client, a gift over to that child's married spouse. A further issue should be canvassed with the client. As a result of a recent amendment to the FLA, a surviving spouse who elects in favor of an equalization of net family properties is required to set off against the equalization entitlement the value of any property acquired as a consequence of the deceased spouse's death, including property received from a third party. This set-off obligation is subject to a contrary intention expressed either by the deceased spouse or by the third party. Hence, the lawyer should ask the client whether the son-in-law or daughter-in-law is to have the bequest in addition to whatever equalization claim made against the estate of the client's deceased child. 103. 2 Doubling up of legacies. A lawyer who prepares mirror wills for a couple should proceed with caution where the clients direct that a cash legacy is to be paid out of the estate after the death of the last to die. The problem here is how to deal with simultaneous deaths. Typically, each will conditions the legacy with the following. If my spouse predeceases me or survives me for a period of less than 30 days, simultaneous deaths or deaths in quick succession within the survivorship period stipulated in the will result in the cash legacy being paid from each of the estates assuming there are sufficient assets in each estate. the lawyer should ask the clients whether they care that the legacy could be doubled up in the event of simultaneous deaths. If the clients do not want that to happen, some other approach should be taken. For example, there might be a proviso that if the clients die within 30 days of one another, the legacy payable out of each estate should be halved. Or, the clients may be prepared to accept that the legacy should be included in only one of the two wills. 3 ultimate distribution scenarios. The lawyer should canvass the possibility that all of the beneficiaries will die before the entire estate has been distributed. This can happen in a number of situations. There is a common disaster involving all of the members of the nuclear family. There is a delayed distribution to a child or children, and no child attains the age specified for the final capital distribution. The beneficiary under a life interest outlives everyone else. However it might happen, the client should indicate what dispositive scheme is to apply in that event. A failure to address this scenario could, for example, result in the spouse from whom the client was separated but not divorced at the time of the client's death inheriting the estate under the intestate succession rules. There are times when the client is indifferent as to how the estate will be distributed if all of the major players are gone. For example, the client may be content to see the intestate distribution rules apply in that situation. In that case, the lawyer should still spell out the rules for 2 reasons. First, it can avoid any uncertainty respecting the time as of which the intestate entitlement is to be determined. Second, it will allow all the persons who would share on an intestacy to benefit from the FLA clause, i.e., the one expressing the testator's intention that the income derived from a beneficiary's bequest shall not form part of the beneficiary's net family property. For example, where the client is content with the intestate distribution rules, the ultimate distribution scheme could be expressed in the following terms: at the date of death of the last to die of my spouse, my issue, and me, the final distribution date, any portion of my estate remaining undisposed of in accordance with the foregoing provisions, the remainder estate shall be distributed to those persons who would have been entitled thereto, and in the same proportions as they would have been respectively so entitled, if I had died on the final distribution date, intestate, unmarried, and without debts, and my estate had consisted solely of the remainder estate. 10.4 Trust issues where the dispositive scheme does not involve an outright distribution, but instead calls for property to be held in trust for a specified period of time or until the happening of a specified event. Certain legal issues will arise. 4. 1. Investment authority. To ascertain the scope of the estate trustee's investment authority, one must look first to the will itself. The lawyer should ensure that the will contains an investment authority that accurately reflects the philosophy and estate planning objectives of the client. The client may have very strong views in this regard. Examples include the following. The estate trustees should avoid risky investments or should restrict investments to those of the blue chip variety. The estate trustees should not dispose of any investments that the client has seen fit to acquire during the client's lifetime. The estate trustees should have carte blanche to invest in whatever manner they see fit. The estate trustees should hire professional investment managers. That is not to say that the lawyer should accept instructions without comment where the lawyer feels they may be inappropriate or problematic in the circumstances. The client may be intent, in spite of any caution or criticism from the lawyer, on imposing a particular investment authority. The lawyer should proceed, as long as the lawyer is satisfied that the instructions are practicable, and, of course, capable of being expressed in clear and objective terms. The lawyer should be familiar with the Investment Authority in the Trustee Act, which will govern when the will is silent, since it may be that the default investment authority fits the client's requirements quite satisfactorily. In this regard, the lawyer should be aware of the following features of the statutory investing rules. Investment in mutual funds is expressly permitted. The trustee has a mandatory duty to diversify the investment portfolio, having regard to the requirements of the trust, and general economic and investment market conditions. Where the client holds an investment portfolio through a holding company or where the client is a significant shareholder of a corporation carrying on an active business, the lawyer should take care to ensure that the mandatory duty to diversify is appropriately curtailed in the will drafting. A trustee may delegate the investment authority to an agent. Provided certain steps are taken, the agent may not further delegate the investment authority. Either the trustee who has delegated to the agent or a beneficiary is entitled to sue the agent who has breached his duty to the trustee. 4. 2. Perpetuities at common law. The rule against perpetuities, sometimes referred to as the rule against remoteness of vesting, requires that all interests in property must vest within the so-called perpetuity period. In the case of a will, the perpetuity period commences on the death of the testator and ends on the 21st anniversary of the date of death of the last relevant life in being at the beginning of the period. At common law, this rule was applied in a most harsh and unforgiving manner. As long as there was even a possibility, however remote, that a gift might vest outside the perpetuity period, the gift was void. That was so, even if, as events actually transpired, the gift would have vested within the perpetuity period. The harshness of the application of the common law rule was substantially attenuated by the enactment of Ontario's Perpetuities Act, applicable to instruments that took effect on or after September 6, 1966. Section 4 of the statute introduced the wait-and-see principle. The mere possibility of a gift's vesting outside the perpetuity period would not result in the gifts being void. Instead, the gift becomes presumptively valid until actual events establish that the gift is incapable of vesting within, or without the perpetuity period. In the former case, the gift would be void. In the latter case, it would be valid. Instances where the perpetuity period is most likely to be inadvertently breached are those where there are successive interests and vesting of each of those interests is postponed for a period greater than 21 years. For example, suppose the testator directs the following disposition of the residuary estate. The residue is to be divided into equal portions for the testator's children, each of whom is to receive the final distribution of trust capital from the child's portion on attaining age 40 if any child dies before age 40, leaving surviving children, that is, the testator's grandchildren. Those grandchildren will take in equal shares per capita the deceased child's portion, with a similar requirement of waiting until age 40, with a further gift over to surviving great-grandchildren where a grandchild dies before age 40. Suppose that there are no grandchildren born at the time of the testator's death, but some are born in the 5-year period after that death. Suppose further that all of the testator's children die within 10 years after the testator's death. In that situation, the relevant lives in being at the testator's death are only his children. The testator's eldest grandchild will be under 10 when the testator's last child dies. The perpetuity period will end on or before the 31st anniversary of the testator's death, but none of the grandchildren will have received a full share by that time, all of them being under age 40. In order to ensure that the interests of a beneficiary cannot vest beyond the perpetuities period, it is common to incorporate a proviso along the following lines, notwithstanding anything to the contrary hereinbefore contained. If on the date 21 years following the date of death of the last survivor of me, my spouse, and those of my issue alive at my death, such date being hereinafter referred to as the vesting date, any portion of a beneficiary's share is undistributed by reason of his or her not having yet attained age, such portion shall be paid or transferred on the vesting date to such beneficiary. 104. 3. Accumulations. Clients are frequently concerned that a beneficiary not have an automatic right to obtain access to income derived from property being held in trust for the beneficiary. This is particularly so where the size and nature of the trust capital are expected to generate a very substantial income stream over time. This concern may motivate the client to direct that the trustees have authority to pay out only so much of the trust income as they see fit and to reinvest the balance of the undistributed income. This desire to reinvest excess income will be circumscribed by the limitations on reinvestment of trust income set out in Ontario's Accumulations Act. That statute sets out a menu of accumulation periods from which one may choose, depending on the circumstances. In the case of a will, the trustees may not be directed to reinvest income for a period in excess of the 21st anniversary of the date of the testator's death. Contraventions of this prohibition can arise where income is distributable on a discretionary basis to a beneficiary for a period in excess of 21 years, or a beneficiary with a succeeding interest to another person. Consider, for example, a will that provides that the testator's surviving spouse will receive all of the income derived from trust capital for the spouse's lifetime and, on the spouse's death, the income will be held in a discretionary trust for the testator's disabled child for the child's lifetime. Because the accumulations period starts to run on the testator's death, it may well run out prior to the death of the spouse, with the result that none of the income derived from the trust during the lifetime of the disabled child may be reinvested. Any direction in violation of the prohibition against excessive accumulation will be null and void, and the income that is the subject of that void direction will go to such person as would have been entitled thereto if such accumulation had not been so directed. Accumulations Act, S1, 6. The weight of authority appears to be that the income that is the subject of that void direction will passes on an intestacy, although there are cases suggesting that this may be too broad a statement and that the particular will must be examined in order to reach the appropriate result. The prudent course to follow in drafting a will is to ensure that there is no inadvertent breach of the Accumulations Act, thereby avoiding any uncertainty as to the ultimate destination of any income that is orphaned by the statute. For this reason, it is advisable to include appropriate limiting words in any direction that gives the trustee discretion as to how much of the income derived from trust capital should be paid out in a year. The following is an example. Notwithstanding the foregoing discretion granted to my trustees respecting distributions of trust income, in each year following the end of the maximum period, if any, authorized by law for my trustees to accumulate the net income derived from the capital of this trust, my trustees shall pay to the beneficiary the whole of the net income derived in that year. As a result of changes to the income tax treatment of testamentary trusts starting in 2016, the client who intends to provide for reinvestment of undistributed trust income should be alerted to the fact that such income will be taxed at the top marginal tax rate. Prior to this change, a testamentary trust was taxable on undistributed income at graduated rates. The only exception to this rule is a testamentary trust for a named beneficiary who qualifies for the disability tax credit. For those trusts only, taxation of undistributed income at graduated rates is still the Rule 104. For Rowland-Saunders v. Vautier, this ancient rule provides that where all of the beneficiaries having an interest in a trust are of the age of majority, they may together demand the distribution of the trust property, notwithstanding a direction that the trustees are to continue to hold the trust property until a specified date or until the happening of a specified event. This rule is based on the succession law principle that one cannot postpone enjoyment of an absolute gift. Accordingly, if a gift, when properly construed, is an absolute one, the beneficiary can demand to receive it upon attaining the age of majority, irrespective of a direction that distribution be delayed until some later time. Similarly, if property is held in trust for a class of beneficiaries, the beneficiaries can collectively demand a distribution when the last of them has attained the age of majority. Typical language that will risk a beneficiary's busting the trust is the following: my trustees shall keep the trust invested until my son attains age 30, at which time they shall pay or transfer the trust capital to him. Avoiding the application of the rule is very simple. It will suffice to provide for a gift over to another or others in the event the beneficiary dies before the date or event described. In that case, one cannot say that the beneficiary has an absolute gift. Rather, vesting of the beneficiary's interest is subject to a condition, either precedent or subsequent, with another or others having an interest as well. The rule in Saunders v. Vautier can be invoked in one situation that is far from obvious. Suppose the client has directed that a trust be established that entitles an adult child to all of the trust income derived during the child's lifetime. What if the client wants to empower the child to dictate, by means of a power of appointment, what is to happen to the trust funds on the child's death? In drafting the trust terms, the lawyer must take care in the language empowering the child to exercise such a power of appointment. If the trust terms provide that the child may do so either by deed or by will, the child may exercise the power of appointment by deed and claim the entire trust property under the rule in Saunders v. Vautier. This principle was established more than 75 years ago by the Supreme Court of Canada in Robinson v. Royal Trust Company. In that case, the court came to this conclusion in spite of the testator's clearly expressed intention that the power of appointment was exercisable only to direct what should happen to the trust property remaining on the income beneficiary's death. This principle was recently affirmed in the Ontario Superior Court of Justice decision in Guest v. Lot 11. Signing the Will 11.1 Formal wills. A formal will must be signed at its physical end by the testator and by at least 2 witnesses. Alternatively, another person on the testator's behalf may sign it in the testator's presence and at the testator's direction. SLRA. S4. 1. Although the statute requires that the testator either sign or acknowledge the signature before at least 2 witnesses who are present at the same time. SLRA. S4. 1. B. Each of the required witnesses need sign only in the presence of the testator. SLRA. S4. 1. C. Nonetheless, it is good practice to have all 3 of the signing parties in the room at the same time while each of them signs. Neither witness should be a beneficiary or the married spouse of a beneficiary. Otherwise, any bequest or devise to the beneficiary will be void, unless a court is satisfied that neither the beneficiary nor the spouse exerted any improper or undue influence on the testator. SLRA, SS 12, 1, n. 3. Subject to these restrictions, there is nothing to preclude the will drafter or an executor from acting as a witness. An affidavit of execution from one of the witnesses should be procured at the time the will is signed or as soon as possible thereafter. This will avoid the problem and added costs where, at the time the will is to be submitted for probate, each of the witnesses is deceased, mentally incapacitated, or cannot be found. 11.2 International wills. Currently, a small number of jurisdictions are signatories to the convention providing a uniform law on the form of an international will. In Canada, the convention has been extended to some, but not all, of the provinces and territories, Ontario being one of them. The declared purpose of the convention is to provide to a greater extent for the respecting of last wills by establishing an additional form of will hereinafter to be called an international will, which if employed, would dispense to some extent with the search for the applicable law. Where a client has assets in one or more foreign jurisdictions, it cannot hurt to comply with the added formalities of execution set out in the convention. These formalities can be found in the annex to the schedule appended to S42 of the SLRA. However, unless the assets are in one of the jurisdictions where the convention has been signed and ratified and has come into force, it will offer no added benefit. A lawyer who wishes to ascertain the status of the convention in a particular foreign jurisdiction can check the UNIDROIT, International Institute for the Unification of Private Law website at https://www.unidroit.org. Status. Successions. 11.3 Holograph wills. In Ontario, it is possible to make a valid will entirely. S6 of the SLRA uses the term wholly, in one's own handwriting again, with the signature of the testator at the physical end of the will. Such a will requires no witnesses or other formalities of execution, while rarely advisable. The ability to make a holograph will or codicil can sometimes be useful in emergency situations, such as the following two. The client knows what the client wants to do, but time or other constraints preclude a meeting with the lawyer. There is no second independent witness available to complete a formal will. In the former situation, it may be sufficient for the lawyer to dictate the essential terms of the will or codicil over the telephone or to send the text via fax or email. However, communication of the necessary terms by fax or email are preferable to telephone communications, as they may serve to provide evidence that will exonerate the lawyer where the client, for whatever reason, fails to follow the lawyer's instruction, giving rise to a claim against the lawyer by a disappointed beneficiary. That said, the lawyer should be cautious about such accommodations for the client. Without a face-to-face meeting with the client, the lawyer may have no way to ascertain whether the client is being subject to undue influence, even if there is no reason to suspect a lack of capacity. Even if the lawyer knows the client well enough so as to have no concern over such issues, the lawyer should be especially reluctant to provide the content for a codicil to the client's will without having had the benefit of seeing the will or a copy of it. What if a person attempts to make a holograph will by filling in the blanks of a do-it-yourself will kit of the type that is often found in bookstores and, in modern times, proliferates on the internet? Canadian case law is clear that if the witnessing formalities are not present, all that can be admitted to probate as a holograph will is the handwritten portion of the document. The handwritten portion must, standing on its own, that is, without any interpretive aid or context that might be provided by the pre-printed portions of the document, reflect its author's intention to have dispositive effect. 12. Will storage. A client who wishes to keep the original will should be advised of the potential problem that can arise if, at the time of the client's death, the original will that was last in the client's possession cannot be found. Namely, the law will presume that the client destroyed the will. If there is insufficient evidence presented to a court to rebut that presumption, the client will be held to have died intestate. For that reason alone, the lawyer would be well advised to prepare one or more copies, true, photostatic, or notarial for the lawyer's own file. Where the client wishes to have the lawyer retain the original will and the lawyer is prepared to accede to the request, the lawyer should have appropriate safekeeping facilities. For example, by renting a safe deposit box with a bank or by retaining the document in a water-resistant and fire-resistant filing cabinet on site. In addition, the lawyer should secure a written direction from the client that if, for any reason, the lawyer is at some future time unable to contact the client, the lawyer may, at the lawyer's own expense, Deposit the will with the local registrar of the Superior Court of Justice. R74.02 allows for such a deposit by a lawyer who has custody of the will and intends to retire from practice, or by a lawyer who has been given the testator's written authority to so deposit the will. Chapter 36 Powers of Attorney 1. Introduction.